Hello landlords, this is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome back. Yesterday, Judge Lawrence Marks, the Chief Administrative Judge of the Courts of the State of New York, issued a memorandum where there are revised procedures now in the handling or addressing of residential and commercial eviction proceedings. That memorandum is what you see now in front of me. Most of the time, as you have seen with our other videos, we spent hours putting them together, analyzing the data, interpreting it for you, and then giving it to you here on our channel. Today, we're not necessarily going to do that. We're going to review this page by page. There's only a few. We're going to read to you parts of it that affect you, the landlords in New York, and may come to a state near you, because some of you in this memorandum are facing the same issues in other states as happening here in New York. We're going to read parts of that to you, and then we're going to give you our commentary and how we feel that these parts are wrong again towards landlords. How many more wrongs can landlords face here in New York? In that, he says that any eviction proceedings that have been filed prior to or after March 17th, those people, those tenants, will not be removed from the property any earlier than October 1st, 2020. That includes the warrants of evictions that are already in the hands of the sheriff, the marshal, and the constable. Those are on hold until October 1st. Now, what we're hoping for is that those enforcing agents, the sheriff, marshal, and the constable, will turn around and serve those notices prior to October 1st, the 14-day requirement, so that by the time October 1st happens or shortly thereafter, the sheriff will complete the execution of the warrant, and it will not be something where they do it after October 1st, and then at 2 to 3 weeks after that, or maybe even longer, before the tenant is removed from the property. So that's any eviction that was filed prior to March 17th and anything after. The ones after March 17th, more than likely you are not going to have them out before October 1st anyway. But here you have the enforcement agents with those papers in hand now, and those tenants can be removed right now. So now it's another month and a half that these tenants get to stay in your property and actually not pay you any rent, and there's nothing you can do about it. Just another issue to make landlords angry. This also pertains to non-payment and holdover evictions. Holdovers where money is not even an issue, where they get to stay, non-payment or holdover, destroying the property, they can all stay until after that day. Those are suspended. Anything filed after March 17th, they're suspended now. So does that mean there's no actual date set to have the case be heard? Or is it that the warrants of eviction are suspended? We believe, from reading it right here, eviction proceedings commenced on or after March 17th, 2020, whether residential or commercial, non-payment or holdover, shall continue to be suspended. Why? Why? The process takes long enough now. Now it's suspended even longer? The other thing that they mention here that we have a real problem with is that eviction proceedings should be conducted remotely whenever the court deems it appropriate for the health, safety, and convenience of participants. Okay. I'm not here for the convenience of tenants. Landlords are inconvenienced of having to go to court to address these matters. When should convenience be a factor in going to court? Nobody wants to go there. It's a matter of life when you're a landlord and a tenant. It happens. But when they talk about it being done remotely, which means you are not going to get in front of a judge, this channel begs the question, why are police courts open? Why are county courts open? If those participants in those courts can go there in person, like I am here right now, in person, why therefore can landlords and tenants not do the same thing? Is this a delay tactic by the state of New York to hinder the eviction process even longer than it already has been? You all know the answer to that. Yes, it is. They may want to deny that, but we know that they're wrong. This is just a delay tactic, and it's not fair to landlords. We were screaming that since this whole thing happened. COVID-19 is unfair to the landlords. So they're talking about having to have it remotely. That goes into another thing that they're looking to have done. Any warrants, any cases that were filed prior to March 17th now, obviously you're not going to be in front of a judge, but they're scheduling it for another type of hearing. And what they're referring to is a virtual settlement conference or status report in front of the judge through a Zoom conference or whatever, Skype, whatever method that they choose to use in that municipality is what they're going to be using. Now, it's required, they're telling me here, it's required, shall apply to all matters at all stages of the eviction process, including any matter where a warrant of eviction has been issued and been delivered to an enforcement agent but has not yet been executed. What that means, landlords, is that even if the sheriff has the warrant in their hand that was granted to you in March for the back rent that the tenant may have owed you from October through March, and you got the judgment and you got the warrant, that's on hold. If it was a holdover and you gave the tenant a 90-day notice to get out, and they're still there, if you took money from the tenant and all the rent, that kills the holdover eviction. You'll have to start all over again. So now you not only had that time frame of not collecting rent, but if you have, your whole case may fall to pieces and you'll have to start all over again. But here's what they're doing that we find are having a real problem with. And I'm going to read this part because it's very important, and then we're going to analyze it. At the conference, the court shall review the procedural history of the matter, confirm compliance with notice requirements. That was already done, and that's why the landlord got the warrant of eviction and the judgment. If it wasn't in compliance with state law, then those two avenues that the landlord was seeking, the judgment and the warrant, should not have been issued. So why are you reviewing it again? Inquire into the effect, if any, that the COVID-19 pandemic has had upon the parties. These judgments, especially when the warrants, not so much the ones after March 17th, they haven't been in front of a judge yet. But when we look at the warrants that have been issued and the judgments already rendered in cases prior to March 17th, why are they being brought up to a status or virtual settlement conference to determine how COVID-19 has affected them? How? This was not around when those decisions were rendered by the court in your jurisdiction. So why are they being brought up again? Why are they being an issue now? How did COVID-19 affect those tenants prior to March 17th? It did not. So why now are those decisions by the court being suspended and possibly overturned? Why? And they're going to review any special relief under state or federal law to which the parties may be entitled in light of the pandemic, including the New York State Tenant Safe Harbor Act that we talked about in a previous video on June 9th, when that act was discussed in the state Senate and the state assembly and signed into law by Governor Cuomo on June 30th. That act basically looks at if they have suffered under that, then all you would get is the judgment for the rent owed, but not the warrant of eviction. That's mainly what the Tenant Safe Harbor Act looks at. It also refers to referring unrepresented parties to local legal service providers, legal aid society, agencies like that, housing counseling agencies, assess any pending and anticipated motions, approve briefing schedules proposed by stipulation of the parties, and use best efforts, including dispute resolution, alternative resolution, to resolve any outstanding issues. The outstanding issue is the tenant didn't leave after the notice to move out on a holdover. They didn't do that. That's the issue. Or the tenant hasn't paid rent in the prior case, or they were coming to court in April or the end of March, and now the tenant hasn't paid the rent since. So therefore there's more rent compounded on what precipitated the initial eviction anyway. So there may be 5-6 months added on to that no rent has been paid. That's the issue that landlords have. That's all that they care about, honestly. They're not getting the rent. So they need to worry about the tenant, oh gee, it's affecting them. Well, it's affecting landlords in a very drastic way. And that's who we need to worry about. That's who the landlord is concerned about. Now what they're doing is that anything commenced after March 16th, like we have said before, they're suspending that. And they want to do what's called a virtual settlement conference. Landlords, we do not support virtual settlement conferences at all. At those settlement conferences, you must have an attorney representing the tenant, and you, the landlord, must have an attorney representing you. During these times of the COVID-19 pandemic, it may be wise to hire legal counsel to help you navigate through these muddy waters that we're all going through. But in essence, you don't need to have a lawyer representing you. You can do this as a pro se that is representing yourself. But at a virtual settlement conference, you cannot do that. Now, what happens at the virtual settlement conference is that the two attorneys prior to this conference will negotiate, come to an agreement, maybe, and then it goes before the judge in a Zoom or Skype or whatever other method of non-person communication happens through the computer. The judge does not render a decision there. The judge just listens to both sides and enters the stipulation on the record. Now, we have learned from one of our local courts that if there's a non-compliance of this virtual settlement conference on behalf of the tenant, there will be no judgment rendered. There will be no warrant of eviction issued. So, the virtual settlement conference begs the question, the million-dollar question, why would I want to do that? Why would I want a virtual settlement conference? All it is the tenant agrees to pay me, and I accept that agreement. Well, I'm sure, landlords, that this is something that you have been trying to do in vain for months. Hey, listen, can we work something out? Can you pay me? We'll work on a payment plan, try to stay current with what you owe. We'll work on the back rent. Can we do that, Mr. and Mrs. Tenant? Can we do that? If you're willing to do that, we can work with you. Landlords have already done this. Why do they want to have to come to a court through a virtual settlement conference and do the same damn thing? It's futile. It's a waste of time and energy. If you're going to do that, why don't we just have the Zoom conference where the judge is there already and hear the case? Render a decision, give the warrant of eviction, give the judgment for what's owed. So in summary, with what's going on here, from Judge Lawrence Mark, a very well-educated gentleman, we're not demeaning any of that, but we have a problem with this new revised procedures on how they're handling evictions. So there's going to be no removal of tenants prior to October 1st. So you may not have your tenant until the middle of October. For those of you that have filed evictions after that, there still is no date set as when you will be able to have your case heard. If you have lawyers representing you, then you can do this virtual settlement conference, but we've already told you that's a foolish idea. And the landlord advocates do not endorse it, and neither do our team. We do not endorse the virtual settlement conferences. So now you're stuck. You've got to wait to have your case heard in front of a live judge. When that one be, we don't know. We know that some courts are saying that this is inappropriate. They need to go forward. These evictions need to go forward. We side with them. We love them. We agree with them. But at the end of the day, the orders from the Chief Judge, Lawrence Marks, is what rules the day as far as going into court. Again, those cases that were heard prior to, even when the ones with the warrants were issued, and the sheriff was driving to the house and got the call to come back, those had to go back in front of the judge to make sure everything was done the right way. And when the tenant says, well, I suffered under COVID-19, therefore I can't get evicted, please don't throw me out. It baffles the mind, it baffles common sense that you, the landlord, even had to have that case addressed in court. Because it wasn't an issue when you evicted the tenant. We've seen that argument before, where a tenant owes January and June's rent, It goes to court and says, well, Your Honor, I lost my job. That's why I couldn't pay my rent. Okay. When did you lose your job? I lost it June 1st. And here we are in court June 28th. I lost my job. And the argument that we have said right along is what happened in January, February, March, April, and May. You had your job then. Why didn't you pay your rent? Don't use the argument you lost your job in June when you owe all those prior months. Don't use the argument. It's foolish. Well, we say the same thing here. How could COVID-19 have any role in the tenant facing a financial hardship back when the judgment was rendered and the warrant was issued? Why? Landlords, this is a put together fast video. As we've said to you many times before, we are here with you. We are here for you. Subscribe to our channel. A lot of you have. A lot of you have made comments. A lot of you are watching. Subscribe to our channel. It helps you. It helps us even more to help you even more. Subscribe, watch, like the channel, like what you've seen, hit the notification bell, and be prepared for more videos to help you. Take care.